Welcome once again to Three Left Turns Make a Right. I am Mark Small. This week we are here to debate Resolved the United States Supreme Court Justice Clarence Thomas should be impeached. My guest opponent this week is George Harris. Welcome, George. He's Marketing Director, Industrial Designer, and partner of 11PD, a business-to-business product development firm specializing in audio-visual consumer products. He has worked in the advertising industry as an art director and creative director for more than 30 years, both on the agency and corporate sides, and he is an Addy Award winner. Before we get to our topic, I just want to plug once again my book, Crime Pays. It's a novel about a fictionalized Ponzi scheme in the mid-1960s, late 1960s in Indiana. It's available either at Amazon.com or at Big Hat Books here in Broad Ripple on the north side of Indianapolis, Indiana. It's in its 220th or 230th printing, I'm not sure. It's a print-on-demand book, so anytime somebody orders a book, another copy is printed, so that's a printing. We're here on Resolved that U.S. Supreme Court Justice Clarence Thomas should be impeached. George is going to take the affirmative today. I'll be a negative. I'm arguing against impeachment. I think first, and I'm not trying to frame your argument for you, but I think that the folks ought to be aware of what is envisioned by impeachment.
My position, and I, since I'm taking the pro-impeachment position today, I am a left-leaning liberal. I'm probably a fiscal conservative, but that has come through having to balance a household budget. And I think the government should do the same thing. However, with Clarence Thomas, I also pay my taxes, and one of the overlying problems I have with his recent allegations by citizens, I believe it was Common Cause, which uncovered that for the last 13 years, Clarence Thomas and his wife Ginny have failed to report sizable portions of her actually her entire income for the last 13 years. One sizable portion from the Heritage Foundation, whom she worked for from 2003 to 2007, and a simple checking of the box that says spousal income was neglected to be done by Clarence Thomas. I should say Justice Thomas, and I find that curious, at the least. I find it to be criminal at the worst if the intent was to hide her income.
Well, and let me point out too to our viewers out there, I don't lean left. I fell over left. I'm all the way over left. I personally don't agree with the judicial philosophy of Justice Thomas. However, impeachment is a process by which, the only process by which an individual can be removed from the Supreme Court of the United States, or indeed a federal judge can be removed from the bench. In order to be impeached, an individual has to have committed high crimes and misdemeanors according to the Constitution of the United States. And looking at the reporting of income as Justice Thomas is required to do, that comes under the Ethics in Government Act of 1978. That's 5A U.S. Code, Section 101 and following. That requires an annual report by Justices of the Supreme Court, the President and Vice President of the United States, various public, federal elected officials, to give financial disclosures for themselves and their spouses to the government so people can see where money is coming into them and what they're spending money on, all following Watergate. That was when the statute went through. There's no indication in that statute that that financial disclosure has to be made under oath or sworn to in any way. The statute itself, Section 104 of the statute, provides that the enforcement of the mechanism is a civil action through the Attorney General's office, and the penalty for someone who knowingly and willfully falsifies information in a report is up to $10,000 fine. It's a civil action. Inherently, that's not criminal. A high crime is a crime that's very serious and not necessarily a felony. A misdemeanor is a crime. Those are criminal actions, and I don't think that Justice Thomas's failure, and he then went back and corrected his forms for the last 12 or 13 years.
I understand that. 1989.
Yeah,
all the way back to 1989.
Yeah. Now, my saying that he shouldn't be impeached doesn't mean that I agree with his judicial philosophy, because he believes in originalism, which I've argued on here before is not, I don't believe is a valid philosophy. But once the person is on the bench, they have a lifetime appointment to be immune from political considerations, and so they can focus on the cases that are before them. And so, in terms of the tax issue, I don't believe that that's a legitimate reason or under the Constitution to remove Justice Thomas.
Okay. Now, once again, since I am on the left, I believe that the court, at this point in history, has been one of the most right-leaning Supreme Courts that I can remember, and I'm 52. And exponentially, as I get older, I'm paying more attention to politics because I'm concerned for my family and where we're going as a country. And when I see the court, an ideal situation would be that everybody on the court's impartial, and everyone is pragmatic, and everyone has intelligent and worthy discussions about any case before them. A second scenario might be that we have 4 liberal justices and 4 conservative justices and 1 swing vote in the middle. What we have now is 4 very conservative justices, 4 moderate ones, and 1 between them. There are no liberal justices on the court as far as I'm concerned. So yes, I would love to have more liberal justices on the court. Since justices are appointed for a lifetime, Clarence Thomas, by those standards, is still a very young judge. That started with Reagan. He was smart enough to start appointing younger judges, so he knew they'd be on the court for a long time, and their conservative views would last throughout their tenure.
I'll disagree with you on that point. I think Nixon started it before that.
All right. Well, okay. Good point. So, we're looking at Article 3, Section 1, this is the only time I'm probably going to quote the Constitution. Paraphrase the Constitution.
I have a copy of it right here.
Yes, I saw. This says basically that the U.S. Constitution explicitly states that a Supreme Court justice who lacks good behavior can be impeached. Now, we discussed this earlier, that good behavior is part of their tenure, and that things done before they're a justice, and I'm only going to mention this once because I want it for reference. Before he's already appointed, Anita Hill's part of the past. There are people that have been calling for his impeachment for what they consider perjury in denying charges there. But what I'm saying is that has nothing to do with this. What I'm looking at is the tax situation that's going on right now, plus his wife's interest in basically starting Liberty. Hold on a second. Her Liberty Central was an organization she started, which the sole purpose of Liberty Central, or one of the sole purposes of Liberty Central, is to nullify or reverse the healthcare reform, or our healthcare reform that just happened, and also the Heritage Foundation, which is also leans in that direction. And I know that Supreme Court justices recuse themselves at their own discretion. I've seen no movement in that direction from Clarence Thomas.
Okay, well, first of all, a recusal would take place case by case.
Yes.
And her group hasn't come up directly before the court on any case of which I'm aware. So there'd be no cause for him to recuse himself. But going back just a moment to the Anita Hill question. So first of all, if he perjured himself in testimony during his Senate confirmation hearings, statutes of limitation would apply. The statute of limitation, as I understand federal law, there are several different statutes of limitations. It depends upon the statute one is discussing. But for perjury itself, not tax perjury, but just vanilla, run-of-the-mill perjury, that has a 5-year statute of limitations.
Right.
If we're deemed to be a fraud upon the court, however, and that would be interpreted very broadly to include the Senate Judiciary Committee as a judiciary body that would affect the judiciary process, there would be no statute of limitations. So, and here's the addendum or the asterisk on that. Criminal statutes are interpreted strictly against the government, so you can't read too much into that.
Mm-hmm.
So just as a commentary on the Anita Hill point and all the stuff that's come out recently going back to his confirmation hearings, I don't think that they're relevant to his being on the court right now as a procedural matter.
Right.
People can have whatever view they want of that proceeding and whether they like him as a justice or not.
Right.
But as far as removal from the bench, it wouldn't apply. As far as his wife's involvement in lobbying efforts, justices don't live in a vacuum. They're human beings, just like, well, I mean, there might be a question about a couple of justices in the past that have been on the court, whether they're human beings, right or left. William O. Douglas turned out bunches of opinions and was kind of an automaton. But they're going to have spouses involved in things. The conventional view has been that a court should not speak out vocally on matters and should be somewhat reserved. That's gone to their spouses too. The fact that she's a lobbyist should be something of which Justice Thomas is aware. It's something of which his wife should be aware because of what she's doing for a living. But unless a specific case comes up that involves her organization, or an example would be a case that affects her organization, such as Citizens United, then there isn't a basis upon which he could recuse himself. We're at the end of our first segment. We'll be back in just a few.